Wednesday, the 1st of October, 1952, Oklahoma City. A small courtroom. Not a district courtroom, a justice of the peace court. The kind of room where cases get decided about whether there's enough to bother a real jury with. There's a 21-year-old woman at the defense table. She got here 45 minutes late with a doctor's note, and her lawyer will not stop talking. He's asked for a delay. Denied. He's asked again. He's asked to move the whole case to a different county. Denied, 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 and he keeps standing back up. Finally, the justice of the peace looks down at him and says, "You talk too much." And the lawyer says, "Yes, sir, I do, but my client's taking a raw deal." And the justice of the peace comes half out of his chair and shouts at him in open court, "You sit down and shut up before I put you in jail." He sat down. That is a defense attorney being threatened with a jail cell for saying out loud that his client wasn't getting a fair shake in a case where a police officer is dead. 5 weeks later, the prosecution agreed with him.
1, 2, 3.
Welcome back to Forgotten True Crime. I'm your host, Trevor Shelby, and this is part 2 of Murder or Nothing. The death of Officer Delbert Beaman, Oklahoma City, 1952. A crossover with my other show, Okie Investigations. Quick housekeeping. If you haven't heard part 1, go back and start there. This one will make a lot more sense. And if you're enjoying this, the best thing you can do for a one-man podcast is share it with somebody and leave a review. It takes 30 seconds and it matters more than you'd think. Same reminder as always. This all comes out of the historical record, Oklahoma newspapers, court documents, census pages. I'll tell you when I'm reading between the lines, and I'll tell you when we simply don't know. Here's where we left it. Sunday night, July the 6th, 1952. A garage apartment at 2112 and a half Northwest 11th Street in Oklahoma City. A 27-year-old police officer named Delbert Beaman and his 21-year-old wife are arguing about a $5 bill. She goes into a dresser drawer looking for the money. His .38 service revolver is in that drawer. One shot. In the stomach. He gets himself down to the neighbor's door and tells her his wife has shot him. His own department comes and runs him to Mercy Hospital, and there a police lieutenant named Robert Grimes leans over him and asks him what happened. And Delbert Beaman says 2 things. He says his wife grabbed the gun and told him, "I'm gonna kill you." And he says, "I don't want anything to happen to Jackie." He died at 1 o'clock in the morning. That's part 1. Today, the courtroom, all of it. The hearing that came apart, the 3 days in January, the 12 people who got handed an impossible choice, and what happened to everybody in this story afterward, including the part I did not expect to find, which took me 2,000 miles from Oklahoma City. Let's go back to the 1st of October, 1952. Monday morning, July the 7th, 1952, Delbert Beaman had been dead for a few hours. Jackie Beaman was arrested and held without bond. The man in charge of the case was the head of the Oklahoma City Homicide Bureau, a captain named Wayne Harbolt. And on Monday, Harbolt told reporters he was going to ask the county attorney to file charges. It's Harbolt who gave the press the detail about the $5. That's how we know that part at all. A homicide captain told a reporter what the fight had been about. And somewhere in there, in an interview room, with her husband's colleague sitting across from her, Jackie Beaman said something that the Associated Press decided to put in the headline. She told the investigating officers she didn't like policemen. Okay, let's just sit with that one for a minute, because I have gone back and forth on it more than anything else in this case. Here is the situation. She is 21 years old. Her husband has been dead for a matter of hours. She is in custody, held without bond, in a police building, being questioned about the death of a police officer by police officers. And what she says is that she doesn't like policemen. Now, read that one way, and it's the single most damaging sentence she could possibly have produced. Its motive: volunteered for free to the people building a case against her. A prosecutor could take those 5 words into a courtroom and do an enormous amount of damage with them, and one of them was going to try. Read it another way, and it's something else entirely, because who says that? Who in that chair, in that building, on that morning, tells a room full of police officers that she doesn't care for their kind? Not somebody being careful, not somebody performing, somebody who is past all that. And here's my honest problem with it, which I have to put in front of you. I have 7 words. That's it. Didn't like policemen. I don't have the sentence before it or the sentence after it. I don't know what she was asked. I don't know if she said it flat and cold or said it crying. I don't know if she said policeman meaning her husband, or meaning the men in that room, or meaning something that had happened to her that we know nothing about. A wire service in 1952 needed a headline, and that was the headline. Everything around it is gone. I want that full statement. It may exist in the Oklahoma City papers of that week, and if I ever get it, I will tell you. That same Monday, they took her in front of a justice of the peace named Paul Powers. And remember that name, because Paul Powers is going to matter a great deal, and not in a way you would guess. She pleaded innocent. The wire copy says she did it between sobs, and then they took her back to her cell in the county jail. Now the machine gets going. Within 36 hours, this story was everywhere in the state of Oklahoma. It ran up north in Blackwell. It ran west in Elk City. It ran clear out in the Panhandle and away over in the northeast corner of the state. It ran in Ada and Enid and Alva and Frederick and Wewoka and Seminole and Holdenville. Every corner of the state inside of 2 days. And this is where the story stops being about 2 people and starts being about what people decided those 2 people were. The papers ran it like this: OC woman who dislikes officers held for murder. A little later, a paper up in the Panhandle ran a story about her under the words slayer of husband. Slayer. She was 21 years old. She had been charged, not tried. There would not be a jury in a box for another 6 months, and a newspaper printed the word slayer over her name. I'm not going to be too hard on those editors. That's how they wrote in 1952, and every one of those papers was working off 4 paragraphs of wire copy and a deadline. But I want you to hold on to those headlines, because when we get to the end of this episode, I'm going to ask you to remember what the papers called her. And here's the part of the coverage that got to me. 2 little papers in this state covered this case differently than everybody else, because to them it wasn't a crime story. It was a hometown story. Down in Seminole County, the Wewoka paper and the Seminole Producer ran their stories under headlines about a former Sassaquan. They dropped their own little boxed paragraph right into the middle of the wire copy to tell their readers who she was. Mrs. Beaman is the former Jacquelyn Kay Collins, daughter of Mr. and Mrs. Luther Collins, and lived most of her life in Sassaquah, attending school there. That's not crime reporting. That's a small town saying, "We know her." And out on the other end, out east of Oklahoma City, in the country where Delbert grew up, the little papers in that township did the same thing for him. They ran his story and then added the part the wire never carried, that Delbert Beaman had lived south of Spencer and gone to the Star School, and that his parents were Mr. and Mrs. A.I. Beaman, two country kids. And in July of 1952, two sets of country neighbors, 100 miles apart, opened their local papers and read about them. One more thing from that week. On Tuesday, July the 8th, the Daily Oklahoman ran photographs of both of them, and I've spent a lot of time with that clipping because of what the paper chose. They did not run a police photograph of Delbert Beaman in his uniform, and they did not run a jail photograph of Jackie. They ran studio portraits, both of them, the kind you'd sit for at a shop downtown and give to your mother. He's in a suit and tie in 3/4 profile. She's in a light blouse with a lace collar, dark hair, looking down and slightly away. I had both of those restored and colorized, and they're up on the blog if you want to see them. And I'll tell you what struck me. They look like a young married couple, which is what they were 19 months earlier at a country church out past Edmond. So that's Monday. Charges coming, a plea entered between sobs, a cell in the county jail, and her name in every paper in Oklahoma over the word Slayer. Then came Tuesday, and on Tuesday, one day after she was arraigned, with her husband not yet in the ground, Jackie Beaman's attorney walked into a district judge's courtroom and did something that nobody covering this case saw coming. He didn't argue that she was innocent. He put on evidence about her. Tuesday, July the 8th, 1952, her lawyer's name was Dave Shepard, and on Tuesday he walked into the courtroom of an Oklahoma County district judge named Albert C. Hunt, and he put on testimony. Not about the gun, not about the dresser drawer, not about the $5. He put on testimony that Jacquelyn Beaman had suffered from epileptic fits for the past 11 years. 11 years. Remember what I told you back at the beginning? That when Jackie Collins was 11 years old, something started and it never stopped. And it was the most important fact in this entire story. That's it. That's the thing. She was born at the end of January 1931. 11 years old puts us in 1942. A little girl in Sassaquah, Oklahoma, in the first year of the war. And from that year forward, for the rest of her life, Jackie Collins had seizures. 6 months later, at her trial, her attorney would put it to the jury in almost exactly those words, that she had been subject to epileptic attacks since she was 11. Now, I need you to understand what that word meant in 1952, and I'm not going to lecture you about it. I'm going to let the newspapers do it, because the newspapers are brutal, and they're right there in the record. When the papers wrote about what happened next, a young woman with a seizure disorder being sent for medical evaluation, here is how they headlined it. A paper in the Panhandle ran, "Slayer of Husband Goes to Asylum." A paper down in Ada ran, Expect ruling on Slayer's sanity. Asylum. Sanity. That's what epilepsy was in 1952. It wasn't a neurological condition you managed with medication and a driver's license restriction. It was a question about your mind. It went in the same box as insanity, and the box was called an asylum, and the newspapers didn't think twice about printing it that way. So when I tell you that Jackie Beaman had epilepsy from the age of 11, understand that she grew up in a country that had decided what that meant about her long before anybody in Oklahoma City had to make a decision about her. Judge Hunt granted the request. He ordered a mental examination. And I want to flag something about that, because it took me a second read to catch it. The defense asked for it. Think about that. Normally, in a murder case, it's the prosecution that wants a defendant examined, or the court that orders it over an objection. Here, 9 days after her husband died, it is Jackie Beaman's own lawyer standing up and asking a judge to have his client examined by doctors. That is not a delay tactic. That is a man who has looked at the facts of his case and decided that the medical question is the case. So here is where the summer of 1952 went for Jacquelyn Kay Beaman. Around Friday, July the 18th, 11 days after her husband died, she was committed to a private psychiatric clinic in Oklahoma City. The papers called it the Coyne Campbell Hospital, or the Coyne Campbell Sleeper Clinic. She was there under observation for 2 weeks. Then on Thursday, July the 31st, they moved her. They transferred her to Central State Hospital down in Norman for a second examination. She was there until Monday, the 11th of August, when they brought her back to a cell in the Oklahoma County Jail. Add it up. From the middle of July to the middle of August, a 21-year-old widow spent the better part of a month inside 2 mental institutions, being looked at by doctors, and then went back to jail. And notice the shape of those 2 examinations, because it tells you something. The first one was at a private clinic, and the defense chose it. The second one was at the state hospital, and when Judge Hunt finally made his ruling, the report he acted on was the report from the state psychiatrist. Somebody wanted their own look. The record doesn't tell me who asked for it or why, but the defense picked the first doctors, and the state got the last word. Here's a small thing I love. The day before Hunt ruled, the Associated Press ran a story saying the judge was expected to decide today, and then this line. Usually reliable sources speculated she would be judged sane and bond set for her release. Usually reliable sources. Somebody in that courthouse told a reporter the answer before the judge said it out loud. And they were exactly right. On Tuesday, the 12th of August, 1952, District Judge Albert C. Hunt ruled that Jacquelyn Kay Beaman was mentally competent and ordered her released on a $10,000 bond to await trial. $10,000 in 1952. That is something like $120,000 today for a girl from Sassaquah whose daddy hadn't worked in 2 years. Somebody found that money. I don't know who, but somebody in her life put up the equivalent of a house to get her out of that jail. And I think that's worth saying out loud, because it means that whatever the papers were printing about her, there were people who did not believe it. Now, the defense had swung for something, and it looked like they'd missed. But here's the thing, and it's the thing that makes this whole case work. So, stay with me for 30 seconds. Being ruled mentally competent answers one question and one question only. Is this person able to stand trial? Can she understand the charge, sit in the room, help her own lawyer? The court said yes, she could. That is a completely different question from what was happening in her body and her brain at 11 o'clock at night on July the 6th in that apartment with a gun in her hand. Nobody had ruled on that. Nobody had even asked it yet. The epilepsy didn't die in August. It just stopped being a reason to avoid a trial and became the thing she was going to be tried on. She walked out on bond on the 12th of August. She had exactly 7 weeks of freedom in front of her. And then a justice of the peace named Paul Powers was going to hold a hearing that got so far out of hand, the prosecution eventually threw the whole thing away and asked to start over. Jackie Beaman was out on bond from the 12th of August, 1952. Where she went, I don't know. Back to her mother's house on Northwest 31st is my guess. She was 21, newly widowed, and charged with murder, and I have a hard time picturing her going back to that garage apartment. But the record doesn't say, and I'm not going to pretend it does. What I know is that she had 7 weeks. Her preliminary hearing got set, and then it got continued, and then it got set again, and continued again. For those of you who haven't sat through one, a preliminary hearing is where the state has to show a judge that it has enough to send somebody to trial. It's not the trial. There's no jury. But it's the first time the prosecution has to put its evidence out loud in a room with the defense sitting right there. And that makes it very often the most revealing day in the whole case. Hers finally happened on Wednesday, the 1st of October, 1952, in the Justice Court of Paul Powers. Remember him? He's the one who took her innocent plea between sobs back in July. It started badly. The hearing was supposed to open at a certain hour, and Jackie Beaman was not there. Her lawyer, Dave Shepard, stood up with a physician's affidavit saying his client was ill and asked for another continuance. And Paul Powers had had enough. He pointed out, correctly, that this hearing had already been put off twice, and he told Shepard he had a choice: produce Mrs. Beaman or forfeit that $10,000 bond. She walked in 45 minutes late. Then the state put on its case, and the state's case that morning was his family. You already know what they said because I told you in the beginning. His brother, Bill Gene Beaman, his brother's wife, Mabel, both of them testifying that back in the spring, Jackie had told them she was going to kill or beat her husband. One of these days I'm going to have to shoot him a blackjack. And both of them, on cross-examination, agreeing they had thought she was joking. That's what the state had, that and a dying man's words. Now Dave Shepard went to work, and the man was relentless. He asked for another delay. Denied. He asked again. He asked Powers for a change of venue. He wanted this case tried somewhere other than Oklahoma County, and you can understand exactly why. A police officer had been killed in Oklahoma City. His fellow officers were witnesses. His department was in the building. Shepard did not believe his client could get 12 fair jurors in the dead man's own town, and he said so, over and over. And Paul Powers got sick of hearing it. At one point, Powers looked at him and said, "You talk too much." And Shepard, and I love this man a little, I'll be honest with you, Shepard fired straight back. "Yes, sir, I do. But my client's taking a raw deal." and Paul Powers came half out of his chair and shouted at him, "You sit down and shut up before I put you in jail." Shepard sat down. Picture that room. A justice of the peace half out of his seat, screaming at a defense attorney that he'll throw him in a cell at a preliminary hearing in a case where a policeman is dead, with the dead man's brother and sister-in-law sitting right there having just testified. And a 21-year-old girl at the table who got there 45 minutes late with a doctor's note. That is the room. At the end of it, Powers bound her over to district court to stand trial for murder without bond. She went back to jail that afternoon. 2 days later, Friday, the 3rd of October, they took her up to district court in front of Judge Hunt, and she pleaded not guilty. And Shepard stood up and moved to dismiss the whole charge. He argued the state didn't have enough evidence. And then he said, on the record, exactly what he thought of the proceeding he had just sat through in Paul Powers' court. He called it nothing more than a kangaroo court. Judge Hunt overruled him and set the case for a jury trial. But, and this matters, Hunt let her out again. $10,000 bond, restored. She was inside for about 2 days. Now, the county attorney's office told reporters they expected to try this case in November. That is not what happened, and here is why. And it is the single strangest thing in this case that has nothing to do with the shooting. On Wednesday, the 5th of November, 1952, an assistant county attorney named Hubert Gibson, remember that name, he's going to be with us to the very end of this story, announced that the state of Oklahoma was going to ask for a brand new preliminary hearing. Not the defense, the prosecution. Gibson said he was going to ask a different district judge, Clarence M. Mills, to send the case back down to a different justice of the peace, a man named Elmo McAllister, and hold the entire preliminary hearing over again from scratch. And he gave his reasons out loud to a newspaper. He said he had decided on it after studying the testimony given at the first hearing, and because Mrs. Beaman contended her constitutional rights were violated. Read that again. Somebody in the county attorney's office sat down with a transcript of what Paul Powers did on the 1st of October, read it all the way through, and concluded that it would not hold up. Prosecutors do not volunteer to redo a hearing they believe in. Ever. It costs them time. It costs them money. It gives the defense another crack at their witnesses, and it makes them look bad. You do it when you have looked at what happened in that room and decided that a higher court is going to look at it too, and you are not going to like what they say. So think about where that leaves Dave Shepard. He lost the continuance. He lost the change of venue. He lost the motion to dismiss. He got told to sit down and shut up. Before he was put in jail, he lost every single ruling in that room. And 5 weeks later, the prosecution walked into the press and gave him the whole hearing back. The loudmouth was right. Now, I have to tell you something I don't know because it bothers me. I cannot tell you whether that second preliminary hearing ever actually happened. Gibson said he was going to ask for it on the 5th of November, and the next time this case surfaces in the newspapers, it is the middle of January 1953, and Jackie Beaman is walking into a district courtroom to be tried for murder. Whatever happened in between, whether Judge Mills granted it, whether Elmo McAllister held it, what came out if he did, I have not found. It's in a court file in Oklahoma County, and I'd love to see it. What I can tell you is that the delay is how a killing in July of 1952 does not get to a jury until the following winter, Tuesday, the 20th of January, 1953. 6.5 months after Delbert Beaman died at Mercy Hospital, the state of Oklahoma finally put his wife on trial for murder. It took 3 days. Oklahoma County District Court, the Honorable Baker H. Maloney presiding. And the first thing I noticed about that courtroom is that Dave Shepard wasn't in it. By January, Jackie Beaman had 2 new lawyers, George Hill, out of McAllister, and Frank Grayson out of Holdenville. Look at a map for a second. McAllister and Holdenville are both down in southeastern Oklahoma. And Holdenville, Frank Grayson's town, is about 15 miles from Sasakwa. Her family had gone home and gotten lawyers from home. For the state, Hubert Gibson. And before the trial started, Gibson told a reporter what his case was going to be. He said he planned to call 10 witnesses. And I'm going to read you how the Wire described them, because it's everything. Mostly police officers and medical men who talked with the victim, Delbert Beaman, 27, before he died. Remember back in Act 3, when I told you I couldn't find one line in the record about powder burns or range or the angle of that shot, and I told you to hold that thought? Look at the witness list. The state of Oklahoma did not go into that courtroom with a ballistics case. It went in with the words of a dying man. 10 witnesses, and most of them are there to tell 12 strangers what Delbert Beaman said in the last 2 hours of his life. That's a powerful case. It is also a narrow case, and narrow cases can break. Then Frank Grayson stood up and told the jury what the defense was. He told them Jackie Beaman had been subject to epileptic attacks since she was 11 years old. He told them that during that argument over the $5 bill, she was thrown into a seizure and that she blacked out. And here is the full shape of it. As the Daily Oklahoman later summarized it, they said she was brought back to reality by the gunshot and her husband's scream. Sit with that image, because it's the defense's entire case in one sentence. In their telling, Jacquelyn Beaman was not in that room, not in any way that counts. She goes into the dresser drawer looking for $5. Something happens in her brain that has been happening since she was 11 years old, and the next thing she is aware of in this world is a gunshot and the sound of her husband screaming. Now, you can believe that or not believe it, but understand what it is legally. It isn't self-defense. It isn't an accident in the ordinary sense of a clumsy mistake. It's a claim that there was no conscious act at all, that nobody in the legal sense did anything. Hold on to that. In about 10 minutes, it is going to become the most important thing in this entire episode. Wednesday, the 21st of January, day 2. Jacquelyn Beaman took the witness stand in her own defense. They started her easy. Grayson asked her the simple things first, the things you ask to settle a nervous witness down: her weight, her age, where she was from. She said her former home was Sasakwa, Oklahoma. The reporter in that courtroom wrote down 2 details about how she said all of it. He wrote that her voice was barely audible, and he wrote that she sobbed frequently. Now, she had already testified earlier to the bones of her account, that her husband was killed when his service pistol accidentally discharged, that the pistol had come out of a dresser drawer while she was going after the $5 bill they'd been arguing about. And I'll note in passing that the way she put it on the stand the pistol fell out of the drawer, isn't quite the way it was reported back in July, where she said it went off as she was putting it back. The papers give both 6 months apart, a 21-year-old under oath, and I'm not going to make more of it than that. And then Frank Grayson asked his client the question the entire trial had been built toward. He asked her to turn and tell the jury everything that happened on July the 6th. Jackie Beaman turned in the witness chair and faced the jury, and she froze. Grayson asked her again. Nothing. He asked her a third time, and a woman came out of the gallery. Her mother, Opal Collins, who the papers only ever called Mrs. Luther Collins, got up and rushed to her daughter's side. And Frank Grayson, her attorney, a lawyer from Holdenville in the middle of a murder trial, picked his client up in his arms and carried her back to her chair. George Hill went out and talked to the reporters. And what Hill said is one of the most human things in this entire record. This is just one of those epileptic attacks. Her hands are cold as ice. They come on like that. He also told them something else. He said he had been afraid all along that she would collapse under the strain of the trial. Judge Maloney recessed the proceedings. All right, let's talk about what just happened, because this is the hinge of the whole case, and I want to be fair to everybody in that room. Her defense was that she blacked out at the moment her husband was shot. She was then asked in front of 12 people to describe that moment, and she blacked out again. There is no cross-examination for that. There is no question Hubert Gibson can ask. He has 10 witnesses lined up who can tell that jury what a dying police officer said, and not one of them touches a young woman who cannot speak. Now, I've read this two ways, and I'm going to give you both, because the newspapers themselves couldn't decide. Look at it one way, and it is the truest possible corroboration of a defense. You can't fake cold hands. You can't fake going away. Everything the defense claimed about her, the jury just watched happen. Look at the other way and notice the timing. Grayson told that jury on Tuesday that his client blacked out during the shooting. She collapsed on Wednesday. Whatever the jury saw, they had been told the day before exactly what it was going to mean. And look at how carefully the reporter wrote it. He didn't write, "she had a seizure." He wrote that she suffered what her attorney termed an epileptic attack. He wrote that she froze in an apparent trance, hedged twice in one paragraph. Even the man in the room wasn't sure. One last thing about that day, and then I'll let it go. That story went out on the wire, the same words, to papers all over Oklahoma. And you can tell exactly how close each town was to Sasakwa by the headline they put on it. Up in Alva, 300 miles away, in the northwest corner, the headline was, "Beaman Trial is Recessed." 15 miles from her hometown, in Holdenville, Frank Grayson's own town, the headline was, "Mrs. Beaman is unable to talk, falls in trance." And under it, a second line, "Voice barely audible." Same story, same day, same words on the wire. One of those towns was reading about a case. The other one was reading about a girl. Thursday, the 22nd of January, 1953, day 3. The trial came back together and the lawyers made their closing arguments. Hubert Gibson stood up in front of that jury and said this: "There are too many coincidences here, too many to make it ring true." And that is honestly A pretty good closing. Because look at what he's got. A gun in a drawer. A woman who told his family she'd have to shoot him one day. A woman who told police she didn't like policemen. A dying man who said she grabbed the gun and told him she was going to kill him. And a seizure, at the exact instant a trigger got pulled. Too many coincidences. And then Frank Grayson got up and answered him with one sentence. And I have to tip my hat because it's a hell of a sentence. If she had wanted to kill Delbert Beaman, she could have pumped his body full of bullets. But only one shot was fired. One shot. If you mean to kill a man, you don't stop at one. And then, with the testimony finished before the jury got the case, a legal argument happened in that courtroom that I would give almost anything to have a transcript of. The county attorney's office asked Judge Maloney to add something to his instructions. They asked him to tell the jury they could also convict Jacquelyn Beaman of manslaughter in the first degree. Now stop and think about how strange that is. The state charged this woman with murder. Murder means she meant to do it. That's the whole case Gibson just argued. The threats, the dying declaration, too many coincidences. Manslaughter is the lesser thing. Manslaughter is what you call it when somebody dies in the heat of a moment, in a quarrel, without a design to kill. It carries years instead of a life sentence. And it is the prosecutor asking for it. Prosecutors do that for exactly one reason. They do it when they can feel a jury slipping away from them, and they would rather have a conviction for something than an acquittal for everything. Hubert Gibson had sat in that room for 3 days. He had watched his own witnesses. He had watched the defendant collapse on the stand. And somewhere in there, he stopped playing to win and started playing not to lose. And her lawyers objected. The defense objected to the lesser charge. They stood up and told Judge Maloney that the state didn't get manslaughter. That on this evidence, they said the crime, and this is their phrase, out of the appellate record, would be murder or nothing. Murder or nothing. There's your title. And that is not a bluff. That is not lawyers being greedy. Once you understand their theory, it is the only thing they could have said. Because manslaughter still requires a person doing something. A culpable act. A wrongful choice in a hot moment. And the defense's whole case was that there was no act at all. A seizure, a blackout, nobody home. If the jury believed that, there was no crime of any size in that apartment. Not murder, not manslaughter, nothing. So they told the judge, don't give them a middle. There isn't one. She's a murderer or she's innocent, and you cannot be a little bit unconscious. Judge Baker H. Maloney heard the argument, and he sided with the defense. In his instructions, Maloney held that a first-degree manslaughter verdict could not be rendered in this case, which means that when the jury of Oklahoma County took this case, they had exactly 2 doors in front of them. Turn Jacquelyn Beaman loose, or send a 21-year-old woman to the state penitentiary for life. Nothing in between. At 11:27 on Thursday morning, the case went to the jury. 7 women, 5 men. And I want to stop on that for 1 second because in 1953 Oklahoma, that is not a small thing. 7 women in a box, deciding what to do about a wife who shot her husband. Their foreman was a man named C.E. Dixon. He was a mail carrier. He lived at 124 Southwest 46. I like knowing that. Somewhere in Oklahoma City, there was a guy who delivered the mail all week and then had to decide this. They deliberated for 48 minutes. And at 12:15, the jury of Oklahoma County came back into that courtroom, not with a verdict, but with a request. They asked to have one witness's testimony read back to them. Out of a 3-day trial, out of 10 state witnesses, out of the defendant's own collapse on the stand, out of everything they had heard, they asked for Lieutenant Robert Grimes, the man from the emergency room at Mercy. And you know what's in that testimony. You've known since the first 2 minutes of this episode. Robert Grimes told that jury that Delbert Beaman said his wife grabbed his gun from a dresser and said, "I'm going to kill you." And Robert Grimes told that jury that Delbert Beaman said, "I don't want anything to happen to Jackie." Both of those sentences were read out loud a second time to 12 people who were about to decide whether that woman went home or went to prison for the rest of her life. I have thought about this a great deal, and I want to be honest with you. I do not know which half of it they came back for. Maybe they wanted to hear the accusation again, to be sure. Maybe they wanted to hear the other thing again. The thing the dead man asked for. Nobody wrote it down. Nobody asked them. They went back in at 2:30 in the afternoon. At 4:35 p.m. on Thursday, the 22nd of January, 1953, they came out. They stepped into the courtroom, careful not to look anyone in the eyes when they delivered their verdict to the judge. For the charge of murder, they found Jacquelyn not guilty. The Daily Oklahoman Reporter noticed that Jacquelyn Beaman had sat through nearly all 3 days of her own murder trial with, his words, little show of emotion. Then Judge Maloney read the verdict that C.E. Dixon handed him, and she came apart. She burst into violent sobbing on her mother's arm, and as they led her out through what the paper called a group of jubilant friends and relatives, she was crying on the shoulder of a woman named Bonnie Biggs, described in the paper as her lifelong friend. Lifelong. That means Sasakwa. That means this woman had known Jackie Collins since they were little girls in a town of a few hundred people, and she was standing in a courthouse hallway in Oklahoma City on a Thursday afternoon in January holding her up. There's a photograph of that moment. It's on the blog. Everybody around her looks happy. She doesn't. Now, afterward, some of those jurors talked to a reporter, and what they said is the single most important thing in this entire case. They said that on the very first ballot, the jury stood 9-3 for acquittal. 9 wanted to let her go. 3 did not. And the 3 who did not, listen to this, the 3 holdouts came over to acquittal because they could not render a manslaughter verdict. There it is. 3 people on that jury looked at this case and did not think Jacquelyn Beaman was innocent. 3 people wanted to convict her of something. They wanted the middle door, the heat of the moment door, the quarrel that went wrong door. And Judge Malone had nailed it shut that morning, at the state's own request, over the defense's objection. So those 3 people had a choice between sending a 21-year-old to prison for the rest of her life over a $5 bill and letting her walk out the front door. They let her walk. The defense's gamble, murder or nothing, did not just work. It worked exactly the way it was designed to work, on the exact 3 people it needed to work on. And we don't have to guess about that, because the jurors said so out loud to a newspaper. 2 more things about that Thursday. The first one is a piece of irony I can't get over. Back in October, Dave Shepard had fought like a badger to get this case out of Oklahoma County. He was certain that his client could not get a fair jury in the city where the dead man wore a badge. An Oklahoma County jury acquitted her in about 3 hours. And the second thing is this. Just before the verdict was read, before anybody in that room knew what those 12 people had decided, Hubert Gibson stood up and served notice that he was appealing Judge Malone's instructions to the Criminal Court of Appeals before the verdict. He told the reporters he knew it couldn't touch her. She'd been tried, and under the law of this country, she could never be tried again for it. But he said a ruling from the higher court will have effect on future cases. He wanted the law fixed. Hold that thought too, because what Hubert Gibson did next is the reason nobody has really ever heard of Jacquelyn Beaman. Jacquelyn walked out of that courthouse on the 22nd of January, 1953, a free woman. Under the law of the United States, she could never be tried for her husband's death again, no matter what anybody found later. 4 months went by. And then on the 13th of May, 1953, somebody filed a lawsuit in Oklahoma County District Court. Case number 130720. The plaintiff was a woman named Maud Beaman, and she was suing as the administratrix of the estate of Delbert Beaman, deceased. I can't prove this yet, and I'll tell you that up front. But Delbert's parents were listed in the papers as Mr. and Mrs. A.I. Beaman, and I am fairly confident Maud Beaman was his mother. And the two defendants in that lawsuit were the Occidental Life Insurance Company of California and Jacquelyn Beaman. What they were fighting over was a group life insurance policy, number 753150, $2,000, about $24,000 in today's money, a young patrolman's death benefit. Now, I want to be careful here because I have the filing and I do not have the petition, so I can't quote you their legal theory. But when the estate of a dead man goes to court to stop a life insurance payout from reaching his widow, and the widow is the person who was accused of killing him, there is really only one thing that argument can be. It's a very old principle. You cannot profit from a death you caused, and here's the part that matters. A criminal jury has to be convinced beyond a reasonable doubt. That's the highest bar in American law, and Jacquelyn Beaman had already cleared it. A civil court is different. In a civil case, you only have to convince the court that something is more likely than not. Lower bar, different room, second try. His family went back to court to prove what the state of Oklahoma could not. And I want you to hold two things next to each other for a second. Delbert Beaman, on a table at Mercy Hospital in the last 2 hours of his life, with a bullet in his stomach, told a police lieutenant, "I don't want anything to happen to Jackie." His mother sued her. I'm not going to sit here and judge Maud Beaman for that. Her 27-year-old son was dead, shot with his own gun, and 12 strangers had just told her that nobody was responsible for it. If it were my son, I don't know what I'd do either. That family had nowhere left to go, and they went to the only place that was still open. There's one more small thing in that filing that tells you how bad it had gotten. An administratrix is what a court appoints when somebody dies without a will, and normally the surviving spouse has first claim on that job. It wasn't Jackie, it was Maud. So somewhere in the Oklahoma County records, there's a second case file, a probate case, where that family and that widow fought over who got to bury him and settle his affairs. I haven't seen it. And I have to tell you the most frustrating sentence in this entire episode. I do not know how that lawsuit came out. I have the day it was filed. I have the answer date. And then the trail goes cold. It's in a courthouse in Oklahoma City, and it is the thing I most want and don't have. Which brings us back to Hubert Gibson. Remember, he gave notice of appeal before the verdict was even read. He wasn't trying to touch Jackie Beaman. He knew he couldn't. He wanted the Criminal Court of Appeals to settle the law for the next case. Whether a trial judge can take manslaughter away from a jury like that, and the county paid for it. Somebody sat down and transcribed that entire 3-day trial into a formal record and sent it up to the higher court at Oklahoma County's expense because Hubert Gibson wanted a ruling. The case was docketed. Number A-11966, State of Oklahoma versus Jacquelyn Kay Beaman. It was set down for oral argument, and nobody came. The state of Oklahoma never filed a brief. On the day it was called, no one appeared for the state. Not Gibson, not the county attorney, nobody. The court's language is dry as a bone. Under such circumstances, we treat the appeal as having been abandoned. I don't know why, but I've got a theory that fits everything, and I'll give it to you for what it's worth. Gibson said he only wanted the law settled for future cases. Well, on the 20th of January, 1954, the Criminal Court of Appeals decided a different case, called Ego versus State, and in it, they answered his exact question. 6 months before the Beaman appeal was ever going to be argued, he'd already gotten his ruling in somebody else's case, so there was nothing left to argue. That's a guess, but it's a guess that explains every fact I have. And here's the thing, the court answered the question anyway. On the 7th of July, 1954, the Oklahoma Criminal Court of Appeals handed down 4 paragraphs in State versus Beaman. And I want to note the date on that because I sat and stared at it for a while. Delbert Beaman died at 1 o'clock in the morning on the 7th of July, 1952. The opinion came down on the 7th of July, 1954, 2 years to the day. And the court said, quoting that Ego case, that where a defendant is charged with murder, it is the duty of the trial court to instruct on manslaughter if there is any evidence that the crime might have been committed under circumstances that would reduce it. And it doesn't matter whether that evidence came from the state's witnesses or the defendants or both. Any evidence. So let's be clear about what that means. Judge Baker H. Maloney got it wrong. And it wasn't a technicality, and it wasn't academic, and we know that for a fact because 3 people sat in that jury room and wanted to return exactly the verdict he had taken away from them. The Criminal Court of Appeals put it in writing in July of 1954. 18 months too late for it to mean a thing. 2 days after that opinion came down, the legal newspaper in Oklahoma City printed it for the lawyers of this state to read. I have that clipping, and I want to describe it to you because it is the reason this episode exists. It's a column of type under the heading Criminal Court of Appeals. Case number A-11966, the State of Oklahoma, plaintiff in error versus Jacquelyn Kay Beaman, defendant in error. Appeal from the District Court of Oklahoma County, the Honorable Baker H. Maloney, Judge. Opinion by Jones. Powell and Brett concurring. And then a syllabus, one long sentence about the duty of a trial court to instruct on manslaughter. That's it. That's the whole thing. There is nothing in it about a garage apartment on Northwest 11th, nothing about a $5 bill, nothing about a woman downstairs opening her door in the middle of the night. Nothing about a little girl in Sasakwa who started having seizures when she was 11 years old. Nothing about a man on a table at Mercy Hospital asking a police lieutenant to go easy on his wife. Nothing about the fact that the state never showed up. Read it cold 70 years later, and it looks like any other decided case. A tidy rule for lawyers to cite. That document is where Delbert and Jackie Beaman went to be forgotten. And it worked. It worked completely for 73 years. So that's the case. An Oklahoma City police officer was shot in the stomach with his own service revolver during an argument about $5, and he died 2 hours later, and his 21-year-old wife was charged with his murder and acquitted in 3 hours by a jury of 7 women and 5 men. Now let me tell you what I actually think. I'll start with what I don't believe, because it's shorter. I do not believe this was murder. I don't think the state proved it, and I don't think it happened. If Jackie Beaman went into that dresser drawer intending to kill her husband, then Frank Grayson's question in closing has never been answered by anybody. Why is there one shot? One. Out of a loaded revolver in a room the size of a garage apartment against a man she'd apparently been planning this for months. You don't fire once and then run down the stairs behind him. And the murder charge asked me to believe that a woman who had been having seizures since she was 11 years old had one at the precise instant that was most convenient for her, and then had another one on the witness stand 6 months later in front of a jury, on cue, complete with hands that a lawyer described as cold as ice. That's a lot. But I'll tell you what, I also don't believe, and this is the harder half, I don't fully believe the blackout either. Not because I doubt the epilepsy. The epilepsy is real, it's documented, it goes back 11 years, and her own lawyers were putting it in front of a judge 9 days after the shooting, before anybody had figured out what the defense would be. That's not manufactured. It's these seams that bother me. Her account changed. In July, she told police the gun went off as she was putting it back in the drawer. On the stand in January, the pistol fell out of the drawer. Small, but not nothing. And her account and Delbert's cannot both be true. She said she didn't pull the trigger intentionally and didn't even know where he was standing. He told Lieutenant Grimes she grabbed the gun and said, "I'm going to kill you." Those are not two people remembering a chaotic moment differently. Those are two completely different events. And there's the thing the state never seems to have had, and that I could not find in a single newspaper: the physical evidence. Powder burns, range, angle. A gun that discharges while it's being set down in a dresser is a very different piece of evidence from a gun fired at a man across a room. Somebody must have looked. Nobody ever printed what they found. And Hubert Gibson walked into that courtroom with 10 witnesses who were there to repeat a dying man's words, which tells me the physical proof was not the strong part of his case. So here's where I come down. I think something was badly wrong in that garage apartment, and I think the truth of what happened in it is somewhere the law of 1952 had no box for. I keep going back to one sentence, and it's not the dying declaration. It's the thing Mabel Beaman testified to. Sometime that spring, Jackie Beaman looked at her husband's brother and her husband's brother's wife and said, "One of these days I'm going to have to shoot him." Have to. That is not the sentence of a woman making a plan. That's the sentence of somebody who thinks a day is coming that she won't be able to get out of, and she said it to his family, the two people most likely to carry it straight back to him, which is either a threat delivered by proxy or it's a woman putting a thing on the record with the only people she had in the only way she could and hoping somebody would ask her what she meant. Nobody asked. They thought she was kidding. They said so under oath. And I have to be straight with you here, because it would be easy for me to take that sentence and build you a story about a battered young wife, and you'd probably believe me, and it might even be true. But there is nothing in this record, not one police call, not one hospital visit, not one neighbor, not one relative, not one line in any newspaper that says Delbert Beaman ever laid a hand on his wife. I looked hard. It is not there. And a woman also told his family she'd take a blackjack to him, which is not the language of someone who's afraid, so I don't get to tell you that story. I only get to tell you that the sentence exists and that it has the words "have to" in the middle of it, and that it has bothered me for 2 weeks. I believe 3 people on that jury got it right. 3 of those 12 looked at all of it. The dying declaration, the threats, the seizure, the one shot, and they landed in the middle. They didn't think she was a murderer. They didn't think she was innocent either. They wanted manslaughter, a death that happened in a hot, stupid, cornered moment over $5 in a one-room apartment on a Sunday night. And I think that's probably what it was. That verdict was available. It was the right size for this case. And it was taken off the table on Thursday morning at the request of the man prosecuting her and over the objection of the men defending her. And 18 months later, a higher court said out loud that taking it away had been a mistake. So the truest verdict in this case is the one nobody was allowed to return. Murder or nothing wasn't just a defense strategy. It was the whole problem. And when you only leave 12 people 2 doors, don't be surprised which one they walk through. There's a lot I still don't know, and I'd rather admit it than dress it up. What was the $5 actually about? Not the money. The money isn't the point. What was the fight underneath the fight? What did she mean when she told those officers she didn't like policemen? I have 6 words and no context, and I want the rest of that sentence more than anything else in this case. What did the physical evidence show? Did that second preliminary hearing ever happen? How did the insurance lawsuit come out? Did his mother win? And the biggest one, why did he protect her? A man is dying. He knows he's dying. He's already told a police lieutenant that his wife took his gun and told him she was going to kill him. And then he spends some of the little breath he has left asking that nothing happened to her. Was that love? Was it guilt? Did Delbert Beaman think in some corner of himself that he had earned it? Or did he know something about his wife that nobody else in that emergency room understood yet? Something about what happens to her when she goes away. And was he trying, in the last minutes of his life, to explain it to a man who didn't have the words yet? I don't know. I've thought about it a lot. I don't know. Now, let me tell you what happened to them. Delbert Ira Beaman was 27 years old. Jacquelyn Kay Beaman was acquitted on the 22nd of January, 1953, 9 days before her 22nd birthday. Her father, Luther Collins, died 3 years later in 1955 in New Mexico. That family did not stay in Oklahoma. They went west, and they kept going, and they ended up in California. And I want to be honest with you about the word believe. I believe I found her. There's a woman in the Social Security death records named Jacquelyn Kay Beaman, born the 31st of January, 1931. Social Security number issued in Oklahoma before 1951, which is exactly what a girl living on Northwest 31st would have gotten as a teenager. She remarried a man named Richard John Skrobajiewski, born in Wisconsin in 1927. He died in San Francisco in 1996. And Jacquelyn Kay Beaman died on the 5th of August, 2003 at San Rafael, California in Marin County. Up above the Golden Gate, about as far from a garage apartment on Northwest 11th Street as a person can get in this country. She was 72 years old. That's not proof. It's the right name, the right middle initial, the right birthday, and a Social Security card issued in Oklahoma in the right years. And if it isn't her, then it's the most remarkable coincidence I've run into doing this show. But I want you to know exactly how sure I am, which is pretty sure and not certain. If it's her, then Jackie Collins of Sasakwa, Oklahoma, lived another 50 years and 6 months after 12 people let her go. She was widowed twice. Once at 21 in a garage apartment, once at 65 in California, and she outlived Delbert Beaman by 51 years. He got 27. She got 72. So let me leave you where I came in. July the 6th, 1952. A garage apartment. $5. One shot from a police revolver. A man gets himself down a flight of stairs and knocks on a stranger's door and tells her his wife has shot him. His own kind of men come and load him into a car. And in an emergency room at Mercy Hospital, a police lieutenant named Robert Grimes leans over him and asks him what happened, and Delbert Beaman names her. And then he says one more thing. I don't want anything to happen to Jackie. The newspapers of this state called her a slayer before a single witness was sworn. A justice of the peace threatened to jail her lawyer for saying she was getting a raw deal. She spent a month of that summer in 2 mental hospitals. His mother sued her for $2,000, and the law of Oklahoma remembers all of it as one dry sentence about jury instructions with her name on the front of it. But that dying man got the last word, and nobody has ever noticed. He asked that nothing happened to Jackie. And he got his wish. Nothing did.